All right. Well, good morning or good afternoon or right at noon, depending on where you are. Welcome and thank you for joining us today on behalf of the whole team here at Silicon Flatirons and our colleagues at the Byron, our White Center for the Study of American Constitutional Law here at Colorado Law. We're grateful to you today for taking the time to join for our event, the United States of Anonymous. My name is Blake Reid. I'm the faculty director of Telecommunications and Platforms Initiative at Silicon Flatirons. Before the program gets underway, just a few brief notes. Today's proceedings are being broadcast live via Zoom webinar. Closed captioning is available to view. Please select the closed caption button marked CC in the bottom of your Zoom window. If you need any assistance on anything today, just drop a note to the organizers in the chat and we will do what we can to help you out. I want to say a special thanks to our supporters who provide mission critical funding to the work we do here at the center. Want to acknowledge that wherever you are joining us from today, we are meeting on the lands of First Nations peoples. The traditional peoples of the land in Boulder are the Cheyenne, Arapaho, and Ute nations, and I'd like to pay particular respects to the elders past, present, and emerging who lead these communities. And finally, want to acknowledge our colleagues, students, families, friends, and neighbors here in Boulder and the surrounding areas who have been affected by the King Super shooting, the Marshall fire, and the NCAR fire. I'm grateful that we're able to gather here today in fellowship and scholarship amid some challenging and difficult times. With that, I'm happy to introduce our featured speaker. Professor Jeff Kosseff is an associate professor of cybersecurity law at the United States Naval Academy in the cyber science department. Professor Kosseff is a decorated researcher and scholar in the areas of cybersecurity regulation, online intermediary liability, and the law of armed conflict as it applies to cyberspace. And in particular, Professor Kosseff has developed a reputation for introducing carefully researched historical pieces that inform hotly contested contemporary debates on internet law and policy. His previous work, The 26 Words That Created the Internet, has become a foundational text in the study of Section 230 of the Communications Act, one of the most important laws underpinning the internet ecosystem today. And today, Professor Kosseff is here to share his latest work, The United States of Anonymous, for which he was named a Carnegie Fellow. In The United States of Anonymous, Professor Kosseff traces the role of anonymous speech from the American Revolution to the internet debates of today. He lays out a thoughtful framework for understanding the critical benefits and harms of anonymity through case studies ranging from the Federalist Papers to the NAACP's membership lists during the Civil Rights era to real name policies on social media platforms. In doing so, he provides a thoughtful and provocative view of how we should think about anonymity in the context of hot button policy debates about how internet platforms should operate. That's really informed by a tremendous degree of history, and it's a book that will prove to no doubt be informative not only for contemporary debates, but as a historical resource in the years to come. Just a brief word about the agenda. Professor Kosseff will speak for the next 35 or 40 minutes. We'll turn to Q&A. As always, our first question will go to a student, and we'll wrap up at about 12:55 Mountain Time. Without further ado, I'm happy to turn the floor over to Professor Jeff Kosseff.
Thanks so much, Blake. I'm really excited to be here. Wish I could be there in person, but I'm thrilled to have the opportunity to talk about my research for this book. I have to start off with just a disclaimer that everything I say is only on my behalf, not on behalf of the DoD, the Navy, or the Naval Academy. So with that out of the way, I wanted to talk a bit about just sort of what got me into writing about this somewhat obscure topic. It's a little less obscure than the last thing I wrote a book about, and it was that book that actually led me to anonymity. And when I was writing the Section 230 book, I would sort of look at all the different justifications, both for and against Section 230. And one of the big defenses, one of the real common ways of justifying Section 230 was saying that all it says is that you can't sue the platform where harmful content is posted, you sue the poster. And that sounds pretty clean, like, okay, you can go sue the person who posted it. But what I saw in a number of the cases and what critics of 230 pointed out is that you can't always sue the poster. There are some reasons not involving anonymity. In part, someone might be located in another country where it's just really not practical to sue them, or they might not have sufficient assets to make it worth suing. But in many cases, you just don't know who the poster is. And there are a few different reasons for that. One could be just logistically that they might be using their neighbor's Wi-Fi connection or the Wi-Fi connection in a coffee shop. So even if you got the IP address, they wouldn't be able to be tracked down. Another would be technological. So they might be using Tor, they might be using VPNs, although VPNs don't really always provide the anonymity that you might think. Or even if they are somehow traceable, so even if they're using an IP address that they or their family members are subscribers to, what the courts have done, and this is what I found so fascinating, is set a pretty high bar to be able to subpoena the identifying information of online posters. And I was just really, just in the same way that Section 230 seemed like, I want to know why we have that. I really wanted to know why we set a much higher bar for discovering the identifying information of online posters than we would for pretty much for most other sort of non-content information. So I started looking at it, and I'll admit that when I started the project, so this was before the pandemic, which seems like about 20 years ago, but I think it was probably 3 years ago that I started really researching the book, and I had probably a much more negative view of anonymity because despite all the research I've done on Section 230, I still kind of went into this thinking that, people would generally only have something to hide if they wanted to do something bad. So that anonymity means that you have some nefarious purpose. And I would say that my views, as I researched and I spoke with people both involved in cases as well as people who have used anonymity, my views changed tremendously. Not to a point where I think that anonymity is an unalloyed social good, but that it's complicated and that there are a number of incredibly valuable uses for anonymous speech, particularly for the most marginalized groups. There also are harmful uses. And the challenge is, how do you balance those equities? And it's difficult, but what I ultimately came to the conclusion is that the strong protections that the United States provides to anonymous speech, unlike most other jurisdictions in the world, that provide some protections, but not nearly as strong, that overall that is where we should be. And that I think that ultimately, and it's probably not as satisfying academically to say that ultimately the courts have come out right. But overall, I think that we have a good balance. I think there are some areas where we don't quite have the right balance, and I'll talk a little bit about those. But when I was looking at these online subpoena cases, all about, trying to subpoena the identity of John Doe, I just keep shepherdizing and tracing back the cases, and these John Doe cases started really around 2000, 2001, as the internet became much more of a home for controversial and at least allegedly defamatory content. But I looked at, what are the courts relying on in those earliest cases? And then I looked there, and they relied on Supreme Court cases involving the restriction of handbills and brochures, that requirements that they had to have people's names signed on them. And I looked at those cases, and they rely on cases that go back even further to the 1950s, involving the NAACP being forced to disclose their member lists. And then I look at the justifications in those early cases, and they go back to the Federalist Papers and the letters of Junius. So I was just like, okay, this is really cool. I've got to trace this now more linearly, starting at the beginning and going forward. So that's what I did. I spent a lot of time with a bunch of very generous archivists in the UK who were helping me with the letters of Junius, which I really refer to Junius as kind of the OG troll. Junius wrote, we still don't know to this day who Junius is. There's generally at least one person who's an aristocrat in England in the 1700s who most scholars think it probably was Junius, but even to this day, we don't know with certainty, and people did not know then. And Junius basically trolled the king. Right sort of before, in the years preceding the Revolutionary War, Junius was in London, wrote letters to the editor of the London Public Advertiser that were so much better than anything you'd see on social media now in terms of trolling. I mean, these were just cutting. And he also criticized the prime minister, who had to step down primarily because of what Junius had written. That is how good Junius was at really getting under their skin. The king really wanted to find out who Junius was, but Junius actually had a number of really sophisticated operational techniques of dropping off letters at various points and having different people pick them up, even supposedly having people copy his penmanship, or copy his writing so his penmanship would not be identified. And he was not found. Unfortunately, his publisher was tried, but ultimately not convicted for seditious libel. And his case, actually, the US Supreme Court would later rely on as one of the benefits of anonymous speech, because that kind of carried over into the colonies, where you had people like Zanger, who also was tried for seditious libel in New York for criticizing the royal governor, but he was publishing anonymous speech. Then you had cases for independence by people like the farmer from Pennsylvania, who later was revealed to be John Dickinson. Thomas Paine writing Common Sense as written by an Englishman. And at least at the time, these were anonymous. And then once we have independence, we have a case that needs to be made for the Federalist Papers, and Hamilton, Madison, and Jay only reveal their identities as the author of the Federalist Papers to a few people and otherwise sign it as Publius. And you can discern some different motivations for being anonymous, and they're not all the same. So, I mean, Junius had a lot of real legal and safety reasons, and possibly some sort of job-related reasons to fear for Junius's safety. When you get to the Federalist Papers, no one's gonna, I mean, obviously Hamilton had own safety concerns down the road, but at least for the Federalist Papers, that's not a legal or immediate safety risk, at least from what we can tell from the communications of the authors. They wanted their identities to be separated from their arguments. They were concerned that if it was signed Hamilton, Madison, and Jay, that would somehow dilute the efficacy of the argument that they were trying to make in favor of ratification of the Constitution. So there are a variety of different motivations for being anonymous. And you see more of the safety and legal reasons carry on into these cases in the 1950s involving the NAACP. So the Supreme Court really doesn't deal with the issue of anonymity until 1958. And this involves a case not even involving speech, but involving the freedom of association under the First Amendment. And so you have in Alabama, sort of in the few years right after Brown versus Board of Education, you have the NAACP working really hard to try to desegregate schools, running into a lot of opposition from Alabama state officials. And the Alabama officials want to shut down the NAACP. And they think they found a way because the NAACP has not properly complied with the registration requirements under their corporation statute. And this should be something really easy to fix. You just file the right paper, pay a $10 fine, and that's it. But the state basically filed a lawsuit to shut down the NAACP because of this violation. And then on top of that, the state, as part of this case, issues a discovery request for all of the members of the NAACP in Alabama. Now, obviously, there's a good reason for Alabama or for the NAACP to not want to disclose their member list. There's very real evidence of retaliation against NAACP members. So they challenge it in the state court where this suit is filed. And unfortunately, the case goes to a judge named Walter Jones. Walter Jones is also familiar to people who know the First Amendment or have studied the First Amendment because he was the state trial court judge who presided over New York Times versus Sullivan, the famous defamation lawsuit that ultimately the US Supreme Court reversed. But this was a few years before that. Walter Jones was a white supremacist, and I use that term very accurately. He wrote newspaper columns in which he advocated for white supremacy. So clearly, you know that the NAACP is not going to have a fair chance in Walter Jones's courtroom, and it does not. Jones temporarily shuts down the NAACP in the state and orders the disclosure of the membership lists, and imposes incredibly high fines, $10,000 a day for every day that it's not produced. So the NAACP, led by Thurgood Marshall, challenges this all the way up to the US Supreme Court, and the US Supreme Court unanimously rules in favor of the NAACP and says that within this freedom of association under the First Amendment, there is a freedom to do so anonymously, particularly when there is a threat of real retaliation, as there was in this case. And so there were a few other cases involving the NAACP, but it was in 1960 when we get the first anonymous speech case. And that also was a civil rights issue. That was an activist in Los Angeles named Manuel Talley. Manuel Talley was passing out handbills outside of a grocery store in Los Angeles, urging the boycott because they purchased products from racially discriminatory suppliers. And he was passing them out, and an LAPD officer cited him for violating a Los Angeles ordinance that required the name of the author to appear on the handbill. And he points out, there's also a store employee right on the same block of that store handing out grocery store flyers, and nobody's name is on there, but he is the one who gets cited. He challenges this citation and ultimately this conviction all the way up to the Supreme Court. And in a 6-3 opinion, the Supreme Court uses the same reasoning essentially as it did in the NAACP case. And but then they also look at the history of anonymous speech, and they cite the Federalist Papers, they cite Junius, and they say, to be able to speak anonymously is part of the freedom of speech. And so that's the first real 1960, that's the first big anonymous speech case that is reinforced 35 years later in a case involving a woman named Margaret McIntyre in Ohio who was protesting a proposed school levy. So she was handing out flyers, protesting them. And there was an Ohio law that said that she had to have that anyone handing out election related flyers had to list the name of the author on the flyer. And she actually tried to, but she'd made some photocopies that didn't have her name on it. So a school superintendent saw her doing this and filed a complaint with the Ohio Elections Commission. I'm seeing something about a pub. I guess, does anyone have any questions so far?
And I'll just say, if folks do have questions, feel free to pose them using the Q&A feature, and we'll try and keep track of that. And Jeff will holler and interrupt if anything's
okay.
Please go ahead.
Okay, so anyway, she the Ohio courts, the Ohio Elections Commission finds her, and she challenges this on principle all the way up to the Supreme Court. She actually dies right before the Supreme Court arguments, but the court lets her husband take up the case for her. And ultimately, the Supreme Court rules in favor of Margaret McIntyre and says that for the same reasons as Manuel Talley's rights were violated under the First Amendment, so were Margaret McIntyre's. And what I found really interesting is that in this, there were a number of different opinions. Justice Ginsburg actually voted with the majority, but she concurred to say, there are going to be some cases where the government's needs, do not justify, or the government's needs are more than enough to justify restrictions on anonymous speech. And but interestingly, Justice Thomas, he issues a concurrence where he agrees with the majority, and the majority applied this exacting scrutiny test, kind of a mid-level test. But he says, we should go further. And he says, I don't agree with their reasoning, because what the majority did is they focused on sort of a tradition of anonymous speech and the value of anonymous speech. And Justice Thomas says, no, that's not why we should recognize this right. He is an originalist. He said, I'm looking at what did the First Amendment mean at the time the Constitution was drafted. And he says, I'm looking at the history of what did it mean to have freedom of press and of speech in the time that the Constitution was written. And so he did a really thorough canvassing of what the press was like back then in the 18th century. And he said he said so much of it, the majority of the speech, the political speech at least, was anonymous or pseudonymous. So there's no way to read freedom of speech or of the press without seeing a right to be anonymous. Interestingly, Justice Scalia, also an originalist, very much disagreed with Thomas, and he dissented. And he said, it doesn't say right to be anonymous, and so there's not an anonymity right. But within his dissent, there was really a distaste for anonymous speech. And that really came through. So that's basically the status at the Supreme Court. They also struck down some restrictions. For example, actually one in Colorado that required, apparently you all have a lot of ballot referenda that we hear about sometimes. And there was a restriction that required the circulators of ballot petitions to have name tags, and the court struck that down. They also struck down an Ohio law, or an Ohio ordinance in a small town in Ohio that required door-to-door canvassers to register with the mayor. This was challenged by the Jehovah's Witnesses, and the court found that violated the right to be anonymous. Now, it's not absolute. There are a number, particularly of campaign finance disclosure requirements, that the Supreme Court has said do pass this exacting scrutiny framework. And I think that's really kind of what Justice Ginsburg was getting at when she cautioned in the McIntyre case that this right to be anonymous is not absolute, and there are times when the government needs may outweigh the individual liberty restrictions. One interesting area before we get to the internet that I rely on scholarship from two of your professors, from Margot Kaminsky and Scott Skinner Thompson, who have written really wonderful pieces about to varying aspects of both wearing masks and also the sort of symbolic expression, are anti-mask laws. And that's not anything having to do with sort of the past few years of mask debates. These were laws that were primarily passed over the past century, some even a little older, in various states and local governments that restrict the ability to wear a mask to cover your face. The laws differ a little bit in terms of what they cover and what their exceptions are, but they primarily were enforced against the Ku Klux Klan, which wears masks and hoods. And the Ku Klux Klan, often represented by the ACLU, would challenge these laws. And they won some cases and they lost some other cases. It's really striking that in many of these cases, they rely directly on the precedent that the NAACP set. But there was one, and to really show the complex equities of this, one case I really focus on quite a bit was in the late 90s in New York City. New York has an anti-mask law, and the NYPD under Rudy Giuliani had told the Ku Klux Klan that if they came to New York, because they wanted to do a rally, that the NYPD would enforce the anti-mask law. So they said, you can come here, but you can't wear masks. And so the Klan challenged this law in federal court. It was this big emergency hearing on a weekend. And I was able to get all the records from that case, and the transcript is very lively, as you might imagine. And but I was looking through all the briefs, and I saw that the National Action Network, which is Al Sharpton's group, had filed a brief in the case. And I just kind of reflexively assumed that, I mean, the KKK stands for everything that Al Sharpton has fought all his life against. So I thought, he's going to support the city's stance on this. But the brief actually supported the KKK's stance. And I found it to be a really intellectually honest and really powerful brief, because what the brief said was, we detest everything that they stand for. But if Rudy Giuliani is able to silence them and violate a fundamental First Amendment right of the KKK, he will do it to us too. And I can't imagine that was a very easy stance for the group to take, but I think it really demonstrates some of the value of being able to speak anonymously, that you would even get Al Sharpton to defend the KKK's stance in that case. And what you see time and again is anonymous speech often being used by the right to anonymous speech being used or invoked by people who otherwise would not have a voice. So you started to see this in the early internet days, being able to speak anonymously. And this was primarily on a board that exists now, but it's different, on Yahoo, called Yahoo Finance. Back in the late 90s, early 2000s, every publicly traded company had a bulletin board on Yahoo Finance. And Yahoo did not require people to post under their real names or even provide their real names. They just required you to sign up with an email address, and they would log your IP address. So people would go on, mostly under pseudonyms, and they would post just absolutely wild stuff about companies. Wild, not as in definitely factually incorrect. Often it was very specific, but it was stuff that you would not normally see in the business sections of newspapers. It was like, the company just laid off 200 people, but they didn't issue a press release, things like that. And it was often very critical of corporate management. And this got under the skin of the corporate executives like you would not imagine. And you would think now this is pretty tame. I mean, now we have Glassdoor, we have Yelp, we have all sorts of places where companies are routinely attacked online. But in the late 90s, this was new. They were not the CEOs, they were used to being publicly criticized sometimes in the media. But if they were, they knew who to complain to. They knew to complain to the reporter or the editor. What they were not used to was having lowly employees be able to just tell the world that management was doing something wrong, or that management was incompetent, or they would do something better than management. And they wanted to find out who these posters were, and they didn't want them working at their companies anymore. So because they couldn't see their names, what they would do is file a civil lawsuit. Usually it was either defamation or claiming a breach of a confidentiality agreement, which was kind of a unique angle because there was no guarantee they were actually employees, but they would file them anyway. And they had no intention of actually collecting money from these people, typically. What they wanted to do was just file the lawsuit as part of early discovery, subpoena the identifying information, figure out who the employees were, and then fire them. And then probably also make it difficult for them to get another job by not giving a good reference. And then they dismiss the case. There were dozens of these cases at one point in the late 90s being filed a week. And what they would do is they'd file the case, they would subpoena Yahoo for any identifying information, and typically what they would just get, they would get whatever email address the person registered with. And sometimes that might have their name in it, but usually it didn't, and they'd get an IP address. Then they'd go to the ISP associated with either the email address or the IP address and issue another subpoena. Now, Yahoo early on, until around 2000, they actually did not even give notice to the people who were the subpoena targets. So they had no idea that their information was being identified or it was being subpoenaed, so they couldn't challenge it. Oftentimes they were back then posting from an AOL account, and AOL did give people notice, but many times it was too late because their AOL account the name might reveal who they are. In around 2000, there were some public interest groups that pressured Yahoo to change their minds on that. And so Yahoo started giving notice. And I mean, I spoke with a number of people who were fired just because of that, because their identities were disclosed by Yahoo. And that really shows the power dynamics in anonymity. It was people who were speaking out against their employers. The vast majority of the time, I read a lot of these complaints from the late 90s, and they were really weak. They were not defamatory. Almost all of them would, if this went on the merits, would be opinion. I mean, it was like, I think the CEO is stupid. That's not going to be a viable defamation claim, but the companies didn't really care about that. Fortunately, you had some people. You had Megan Gray, who until recently was the general counsel of DuckDuckGo, but back in the late 90s, early 2000s, she was an associate at a big firm in Los Angeles, and her firm just let her do internet stuff because she was like their internet expert. So she started doing a lot of pro bono cases for these John Doe defendants. And you also had Electronic Frontier Foundation, and you had Paul Levy at Public Citizen, who started to really, they formed kind of like a ragtag group of advocates saying, we need to protect anonymous speech. And ultimately, by the mid-2000s, they were able to, with Yahoo notifying people, they were able to either file amicus briefs or represent directly many of these defendants. And they got the courts to set what I think overall is a pretty good standard for protecting anonymous speech. It does not say there's an absolute protection, but it provides a number of procedural safeguards, and it varies a bit by jurisdiction. But it's the most important part is it says you have to have a pretty strong case. So we're going to actually scrutinize the case, and many times also scrutinize the evidence that you have for the case before we unmask someone. And what this has done is, in most of the cases, we still see some of these like thin-skinned executive type lawsuits, but you see less of them because they're just ultimately not going to be as successful. I think also you have a bit of a Streisand effect type issue where the company will risk drawing more attention to the fact that it has filed a lawsuit. So you've seen less of those, but I think overall that's set a good precedent. Now, unfortunately, there are some weaknesses in the protections from subpoenas. One area that I highlight in the book involves copyright. So this standard was really set in the early 2000s. If any of you can recall, when the recording industry had taken the step of dealing with online infringement, they first started using DMCA subpoenas, but ultimately the DC Circuit and some other courts said you can't do that. So they started filing these similar John Doe type lawsuits. And the ultimate standard that was developed was a lower standard than you see in these defamation and trade secret and confidentiality cases, where the courts basically say, there's less expressive value in copyright or in peer-to-peer sharing for a variety of reasons. They set a lower bar, so it's much easier to get defendants identifying information in these copyright cases. And what we've seen in the past decade is the majority of these John Doe copyright cases are now filed by companies that own the copyright to pornography. And they often result in pretty high settlements because effectively the choice that people have is either pay a settlement or be unmasked publicly as having shared or downloaded legal pornography. And at least one federal judge has said this is effectively an extortion scheme. So this is one area. I think there's a number of reasons why that I go through in the book about why I think we need to have better protections in those cases. Also, when the government tries to subpoena the information, for criminal cases or administrative cases, we don't have much case law because typically for grand jury subpoenas, there's not going to be an opportunity to challenge it. But in the little case law that we have, it's a pretty low bar, and I think we need to really look at that. I look at sort of some cases both of online harassment as well as beneficial uses for citizen journalists and other people, but of anonymity. But ultimately, what I look at is I know we want to get to the Q&A pretty soon. It looks like we've got some that I want to talk about. But ultimately, what I look at is the future for anonymity. And one point that I try to drive home in the book is that we really have been relying on First Amendment protections for anonymous speech. And the First Amendment will apply, if the government were to try to impose a law requiring real names. I think that almost definitely would fail. It also would apply to subpoenas because those are issued through courts. But the First Amendment applies to government-related actions. To the extent that a private platform says you must use your real name and this is our decision, like Facebook does, like Google Plus did, like LinkedIn does, then there's fewer opportunities for anonymous speech. The good news is we have Twitter, Reddit, other forums that actually explicitly choose not to require real names. So we at least have a good marketplace for that. Bigger challenges include what Michael Frumkin has called self-surveillance. And that's just that, people might think they're anonymous, but you're putting all this information out there about yourself. So you're really not going to be anonymous. And the bigger, I think the way to address that is just be aware, like, do you need to put all of that on an Instagram, and could it possibly identify your pseudonymous posts? And I think people just need to be cautious of that. But the biggest challenge we have now is the vast amount of information that companies have about people and the very limited ways in which their collection, use, and sharing of this identifying information is regulated. And in addition to just sort of traditional online browsing habits and things like that, I'm more concerned about newer technologies like facial recognition. I encourage everyone to read Kashmir Hill's reporting on Clearview AI, and geolocation data brokers that basically traffic in all of your geolocation data. Even if your name is not associated with it, you often can identify people. And so I look at what do we do about this? And there are a few different ways legally to address this through privacy law. One is what a number of laws, including the GDPR, have, which is incentives to anonymize or pseudonymize data. I think that could be moderately helpful, but I also worry that we too often assume that data is anonymized when it really is not. So I think we need to look at that and also look at ways to add noise to data sets and things like that. I think that another way is sort of the CCPA route of providing choice and the ability to have data deleted. I think that can be marginally helpful as well. The challenge is, like, when you look at geolocation data brokers and all of these companies that have the data, that's putting an awful lot of burden on the individuals. So I think we need to look at that. And the third way is looking at like what San Francisco and Boston have done with facial recognition. And they've just said, we will not let our law enforcement use this data. And I think we need to take a hard look as a society at certain types of uses, collection, and sharing that we think are just too damaging to both the ability to be anonymous as well as other privacy equities. So I think we really need to look at that, but I do think that we need to be more serious about privacy law if we want to continue our ability to be anonymous. So it looks like we've got some questions, so I'm happy to take those or keep talking.
Well, Professor Kosseff, thanks very much for the outstanding talk here. And actually, in Silicon Flatirons tradition, we've got some ringer students teed up to ask our first couple of questions here, and then I'll pull some out of the Q&A here. So you're going to get surprised by a couple you haven't been quietly preparing for while you've been talking here. I think our first question is going to come from Catherine Kelly. Catherine, are you able to be promoted as a panelist and come in and ask a question?
Yes, I think I'm now a panelist, if everyone can see me and hear me.
you are now a non-anonymous panelist. Over to you.
Great. Thanks, Professor Reid. And thank you so much for being here. Professor Kosseff, I really enjoyed hearing just more about your book. I was reading your protocol interview a couple of days ago, and it was fun to hear you expand on some of those points in there. But I guess my question is more related to what you're speaking about at the end, looking forward in privacy legislation, since so many companies defer to kind of the bar set. So whether that's the GDPR or CCPA, specifically in terms of the GDPR, it feels really strange that some companies, like our major social media companies, will be deferring to a European standard when so much of privacy law is, and our hesitance to legislate is surrounded by very American ideas on the First Amendment and First Amendment protections. Do you have any hope for a national or federal legislation action around privacy, or do you think we're going to be kind of keep attacking this on a piecemeal basis? And I guess, what does that mean for the more the ideals of our First Amendment and privacy?
Yeah, so that's a great question. So you say if I have any hope for privacy legislation, I guess I would differentiate hope for desire. So I desire national privacy legislation. Politically, I'm not terribly hopeful that it will actually, or I'm not terribly optimistic that it will happen. And this is, so I mean, primarily because of Section 230, I meet with congressional staffers and members of Congress pretty much every week. And they often will just say, we need to do something about big tech. And I say, well, okay, what in particular? And oftentimes it's specific concerns about primarily what Facebook is doing with people's personal information. And so I will always say, okay, well, Section 230 is probably not going to get you there, but you know what will is a good, strong national privacy law with a private right of action that will scare these companies into doing the right thing. And they always say, oh yeah, but that's not going to happen. And I'm like, well, but it could. You're there, like you're in Congress. It could happen. But I think politically it's difficult because the privacy laws affect companies that go far beyond sort of the companies that are the few big tech companies. And I think there are just too many lobbyists, and it's an incredibly unsatisfying answer. But I think the realities are that the lobbyists are just going to keep we're going to keep hearing about it, about proposals, but I'm just not terribly optimistic, and I wish I could be.
Thanks very much for the question, Catherine. I think our second student question goes to Ali Pontius. Ali, are you with us?
Yes, Professor Reid, I think I am with you guys. Thank you so much.
Over to you.
Thank you so much for the talk, Professor Kosseff. It was really interesting to hear you speak on your book. I was just wondering, kind of similar to what Catherine asked, as you mentioned the balancing test that Justice Ginsburg articulated, I was just wondering if you see courts sort of moving in this direction in terms of treating anonymity in the online space, particularly social media platforms, given sort of the prevalence, especially in the past few years, of violence motivated by like racist and certain political ideologies.
Yeah, I think on the online space, it's mainly been the subpoena cases, and I think they do have, I mean, they all have sort of a safety valve for the cases where there is sufficient evidence of harm. Now, there haven't been many subpoenas that have resulted, at least in published opinions, but the ones that have, I generally agree with, where they've allowed the information. One case that I write about in the book quite a bit was a case from 2008, I believe, involving this horrible website called AutoAdmit, which is anonymous, and it appears in my book a few times. They claim to be a law school bulletin board for people who are interested in going to law school, but they basically, a lot of their members launched this really horrific campaign against female law students at Yale. Two of them sued 39 anonymous posters, and the challenge was that AutoAdmit was not logging IP addresses. They made that conscious choice to not do that, and they ended up one of the posters, they did get his IP address, and they issued a subpoena to his ISP. He challenged it, and the judge said, "No, I'm not going to quash the subpoena. There's a really strong case of defamation. You accused these two students of horrible things, and this on its face is defamatory." So I think overall the courts have done that balancing, even though the finger is on the scale of protecting anonymity.
Thanks very much for the question, Ali. I want to turn to some of the questions in the Q&A now. And Professor Kosseff, I want to start with one by the cheekily submitted anonymous attendee who noticed in their review years ago of anonymous speech cases was a shift from McIntyre, which you discussed today and extensively in your book, characterizing anonymity as necessary to prevent reprisal, to characterizing it primarily as interfering with an authorial choice, i.e. the choice not to sign your name or compelled speech under the First Amendment. The first theory advocated by Justice Scalia could require a showing of harm, which was his preference in as much as he couldn't put the anonymous cat back in the bag. The second theory focused on the fact of state action compelling identification. So two questions emerging from that. Number one, is the election case law sui generis in focusing on whether the speaker is experiencing an actual or measurable chilling effect, or do you read that as applying to all anonymous speech claims? And number two, is there room for a First Amendment anonymous speech right where there is state surveillance but not an affirmative requirement of self-identification? So that's a tough one. Shots fired. Over to you.
Yeah, so I mean, I think the election cases are interesting. Justice Thomas dissented, I'll say the campaign finance cases are interesting. So particularly McConnell and Citizens United, where the courts ultimately upheld disclosure requirements, in part because they said, there is not this demonstration of harm, of reprisal. Now, Justice Thomas disagreed, and I believe it was in Citizens United, he used the Proposition 8 framework, where he basically said, or debate in California, where he said there was reprisal, there were harms. I do think the court shifts in sort of it a bit in sort of what it allows as a justification for anonymous speech. It has not been terribly consistent. Justice Scalia's writings, though, generally suggested that he just frankly did not think that there were many legitimate uses for anonymous speech. And the second one, that was saying, is there a First Amendment right to...
Yeah, can you have a room for a First Amendment anonymous speech right if the state is engaging in surveillance, but there's no affirmative requirement of self-identification? So, in other words, could anonymity be implicated simply by the state engaging in surveillance?
Yeah, so I mean, that's definitely an argument that Michael Frumkins made, that basically that these rights to be anonymous can be pierced. And I mean, this is where, and in the book, I sort of look at how the Fourth Amendment really should be addressing this more. And we've had some scholars who have argued that there is a right to anonymity that should be inherent within the Fourth Amendment, but it hasn't been under the Katz framework. And I think I think that would probably be the better approach when you're dealing with state surveillance is to, it's been somewhat disappointing even post Carpenter that the data that really gets at piercing anonymity still is not any more protected than it was even before Carpenter. So, but I do think that that would have been the better avenue to address this.
So I want to ask a related question. Eric Alston asks for your take on how economic and financial privacy are situated within the broader history that you describe in the book, including as weighed against the government interests associated with criminal enforcement of tax collection and money laundering. Any thoughts on financial and economic privacy?
Yeah, so I didn't. There were certain things that I did not really examine all that closely in the book, and that was one of them. Also, the secret ballot. I tried to stick as close to anything related to either speaking or receiving speech as possible. So those generally have not been been addressed as much under at least the First Amendment case law that I looked at.
Let me jump down to, I think this is a question from a grad here from Sean Owens. What is the worst consequence of anonymous speech that you've encountered in your research?
Okay, so there's a good friend of mine named Carrie Goldberg, and she has a law firm that entirely represents people who have been the victims of online harms like cyber stalking and harassment. And when I was writing this book early on, I went to her and I said, I need a case that really shows how someone can cause harm with anonymity. And she gave me one. It was one of her clients. I devote most of chapter 13 to it. I don't really have enough time to explain it in here. I encourage you to read chapter 13, but it was basically a woman in her 20s who had a housemate for about a month who basically accessed all her online accounts. He was a computer science major in college, so he was very good at remaining anonymous. He turned her life upside down. He turned her family's life upside down. He turned her friends and her employers' lives upside down. And when it went on for months and months, he was using Tor and VPNs and so forth, being anonymous enough to avoid prosecution. And fortunately, Carrie worked with the FBI and was able to, they were able to finally arrest him, and he pled guilty and was sentenced to 17 and a half years in prison. I could give a whole hour talk about this. This really changed a lot of my views about anonymity and speech online generally, so that if there was, and actually much of it is excerpted in Slate about a week and a half ago. So I encourage you to read that.
So Jeff, just a quick follow-up question on that. Are there, as you were studying, and I think this is the example involving Ryan Lynn, it's a really powerful and challenging to read example. As your thinking changed in researching that example, did your thinking change about kinds of remedies that might work in those cases, or that might tailor back anonymity in cases like that? Or do you feel like the law enforcement efforts that Carrie and working with the authorities was able to sort of leverage in that case were enough? What do you think about remedies in light of a case like that?
Yeah, so I don't think that I don't think the First Amendment was a challenge in this case, because had there been any subpoena, either civil or criminal, I mean, there was more than enough ability legally to get the information. This was, I mean, she had first gone to local police who wanted to help her. A local police officer took computer classes to try to help her. And I mean, ultimately it was because Carrie was able to get the FBI involved, but and the reason they got involved is part of the harassment involved bomb threats and child sex abuse material, which if it had not, it very well could not have been a federal case. And I mean, I think part of it really, frankly, comes down to having law enforcement prioritize online harms like the cases Carrie deals with every day to the same extent they prioritize offline harms. And hearing her experience with local police really was scary, because you'd imagine, like, if there was an incident involving someone with a gun, you wouldn't go to law enforcement and they say, oh, we don't know how to deal with guns like that. And I mean, I think we really need to rethink what our priorities are here.
So, Jeff, I want to close with one last, I think, a little bit more lighthearted question, although maybe not, depending on how you want to take it. From Matt. Matt asks, "What do you think about a political candidate running anonymously as a method for focusing all people on their policies instead of their personalities?" So, I think grappling with some of the themes you teed up at the beginning of the book about the motivations of the speech motivation for folks to engage in anonymity. What do you think?
Yeah, I mean, I'd imagine there is not an election law in the United States that would allow it, but it's intriguing. I mean, I think it definitely could focus on the issues. When I was a newspaper reporter, I had an editor who would always cut out the party affiliation from a quote about a politician, and his belief was, I want people to read about this politician and judge their argument based on the argument and not based on their party. So I think that's an interesting thought.
Well, Professor Kosseff, with our enormous thanks to you for the talk today, I also want to offer our thanks to our audience, both for tuning in and for asking some really terrific questions. And I also want to say thanks to the folks at Silicon Flatirons, including Nate Mariotti, Shannon Sturgeon, and Catherine Coble, for making this event happen. And for everyone else, we wish you well and look forward to seeing you at a future event. Thanks so much.